Namaskar. I'm Dilip Singh, an advocate practicing in Delhi, mainly in constitutional side in Supreme Court of Delhi High Court. You are welcome to this video, my video channel, my YouTube channel, Constitutional Journey. In this Constitutional Journey video, I'll be taking you to the different articles of the Constitution from the day of inception, that is the Constituent Assembly discussion, till recent judgment pronouncement or any constitutional amendment which has come in that article. This video is to benefit one and all, whether he is a student of law or a practicing advocate or a candidate for judicial examination or civil service examination or a legal officer. So I'm making this video to all who has interest in the Constitution of India. So the perspective of making this video is very wide, and so I'll discuss in this video, particularly in this video, Article 14 of the Constitution, which is right to equality from the past experiences, with the past experiences as well as the future perspective. Before I proceed, let me ask you a question. What were your feeling when you saw hundreds of migrant laborers walking on foot without having sufficient food and to eat, and with their children at the soldier and their goods, their belongings carried by their female part while going to their villages? What what feeling you got? Look, this is a very peculiar situation we have faced in India when the lockdown was imposed. Just let me say, imagine how Dr. Ambedkar would have felt when he would have seen these migrant laborers or the poors for whom he fought all along his life, passing, walking to their villages on this on the their foot. So at this stage, when we have already completed 70 years of our constitution, as you know, it was adopted on 26th of January 1950. So we have already crossed the 70 years milestone of the constitutional journey. This lockdown has given us an unprecedented experience where the rights of poor or marginalized sections of people have been not considered in the way as it should have been. So this has given us an opportunity to think of the fundamental rights in the present state of affairs. Supreme Court, in one of his decision of Basheshwar Nath versus Commissioner of Income Tax, said that Article 14 is founded on sound public policy recognized in all civilized societies. So we need to see the developments in our constitution, in our societies, of the constitutional rights. Before I proceed further, let me produce to you the article text of the Article 14, which is in very simple language. And Article 14 says, the state shall not deny to any person equality before law or equal protection of law in the territory of the society. So here in this Article 14, three important words are here which we need to discuss first, then we will proceed further. First is the state. State here signifies all government actions, whether it is judiciary, whether it is legislature or executive, including parliament, central government, state legislature, local authorities, or any other authorities. State has been very comprehensively defined in Article 12. Now, the other word is to the person. Here, particularly, the framers of the Constitution kept this right to equality for all, citizen or non-citizen, whereas there are other fundamental rights which are available only to the citizens, but the right to equality is available to all. The third word is within territory of India. The territory of India has been defined in the part 1, so it has also very significance. Now, besides this, there are two important legal concepts which are given in Article 14. These are equality before law and equal protection to law, equal protection of law. So this Article 14 combines two very important concepts: equality before law, which has been derived from the English law. This is an English concept. And equal protection of law. This is derived from the 14th Amendment of the Constitution of America, which has origin from the American fundamental rights concept. Let me share a personal feeling to you. As I think, it was a matter of great significance and fortune for us that in the Constituent Assembly, the head of the drafting commission, the chairman of the drafting commission, was a person who himself had suffered throughout his life the discrimination by due to the prevailing caste system. So he could understand the sentiment of the Indian society, and he was very careful while framing this language of the fundamental right. Even that he was also the chairman or head of the advisory committee on the fundamental rights, which were constituted by the Constituent Assembly. So, what I feel that generations of the Indian society have benefited by the wisdom, by the erudition, by the knowledge of Dr. Bhimrao Ambedkar. I salute to his every contribution to the Constitution, and particularly for the enshrining and very beautifully describing all the fundamental rights and putting it at a proper place. He was so concerned about the fundamental right that he placed the fundamental right in chapter 3, just after chapter 1 and 2. In chapter 1, the union is defined. In chapter 2, it deals with the citizenship, and immediately thereafter, fundamental rights. To most of us, these two concepts of equality before law and the equal protection of law are one and same. Even in some of the judicial pronouncement, the Supreme Court judges have taken it on the similar footing. But these concepts are very different, and it was very great extent it was debated before the Constituent Assembly and the Advisory Committee of the Constituent Assembly that what should be the language of the right to equality. But let me share you one thing very interesting, that when the Advisory Committee formed this right to equality, it kept it with the right to life, and it was the second part of the right to life. The same language was there. But later on, the Constituent Assembly separated it and put in the two different rights. So, the concept of equality before law and equal protection of law were taken from the two different backgrounds for the reason that the equality before law is basically an English concept, and it was developed by Professor Dicey. Professor Dicey Professor Dicey has developed his concept of rule of law, and there are 5 principles of rule of law which establishes in the democratic context for ensuring the rights of the uh, people. These concepts are first the rule of law. Dicey has developed a supremacy of law, equality before law, and similarly with accountability to law. Third, fairness in the application of the law by procedure and law transparency. Fourth is separation of power, and five is avoidance of arbitrariness. So this all concept of rule of law was in a manner included in the concept of equality before law. But founding father of the constitution found one thing which made them to give a second thinking. First, it was the concept of British rule of law, where the parliament is supreme. So, judicial review of legislative action or legislature is not permitted. Only executive action can be put to the judicial review. Whereas the concept of protection before law, which is a positive concept, there that is developed in America, and that has a period of 80 years of development of this fundamental right of equality before equal protection of law in the America, and judiciary had evolved this concept very nicely. So, however, it is pertinent to mention here that the concept of rule of law, even prior to Dicey, was developed from the time of Magna Carta, which was adopted in 1215. So, in among the framers of the Constitution, they didn't want to take any chance. So, out of abundance of precaution, they adopted both these concepts coming from the two democratic countries where fundamental rights are respected and have a tradition of giving proper care to the citizens for their fundamental rights. Now, basic concept of equality before law is no one is above law. It is taken as negative concept also because it signifies the avoidance of any privilege to anyone, any privilege given to any section of society or any person, whereas similarly placed persons are not given that privilege. So the thing which comes out from the equality before law is everyone is equal before the law, and everyone has equal responsibility to law, and no one is above law. We will see this concept or in wider context when we will consider the various judicial pronouncements, decisions of the Supreme Court later on of this video or in the next video. The next concept is equal protection of law. This is a positive concept because equality before law say equal should be treated equally. Here the concept comes unequal should be treated unequally. Means the law has a command to create a level playing field for all those persons who are having certain disadvantages in the society. So this is a positive concept, and necessary corollary of it comes from that the equal would be treated equally whilst unequal should be treated unequally. Article 14. Now we can sum up in the way that all persons who are equal or alike may be treated alike, but persons in like circumstances must be treated alike. So persons on equal footing should be treated equally. This is the basic concept of equality before law. In United States, by the 14th Amendment, this concept was included, the protection of law was included, and American Supreme Court within the period of this decade has developed this law to a greater extent, and after adoption of Constitution in India, when thus this matter came before the Supreme Court, then the Supreme Court heavily relied on the experiences of the American Supreme Court which they have developed their own parameter and to, to for the evolution of this equal protection of law. In India, there was a different context. In America, first the society evolved, then they formed this equal protection of law. Here, the task of developing a society equally was given to the constitution and the government. So it was a reverse process. Their society developed, they came with the conclusion, and then the act was put in the statute. Here, the act was first put in the statute, and the act was given, the constitutional act was given, constitution was given this power, this work, this mandate to provide the equality and equal protection of the law to the society. The interpretation of equality before law, equal protection of law, depends upon one fact. Organically or fundamentally, humans are and human circumstances are not equal. There is no concept, there is nothing like absolute equality among human beings. So the necessary corollary is that inequality is common and is prevalent in every society among the persons. So to accept that and to reconcile that, reconcile this inequality in the constitutional law, it became necessary, and it was necessary. This is necessary that certain classification, gradation, or differentiation should be accepted for the development of the society. That's why, in one judgment, the Supreme Court has rightly said any inequality, in order to be unconstitutional, must be actually palpable, unreasonable, and arbitrary. Means classification will be there. If that classification is to be found unequal, then it has to be substantially unequal. And on these premises, Supreme Court developed the concept and developed the theory of, they developed the doctrine of classification, which was based on, which identified two basic ideas. First, intelligible differentia, and second, rational nexus. Here I want to say that the classification was accepted because it was found that fundamentally inequality is there. But to sustain that classification on the touchstone of fundamental right of equality, two necessary tests were developed, that is intelligible differentia and rational nexus. From the very first case which came before the Supreme Court on the ground of this right to equality was the Chiranjit Lal Chaudhary versus Union of India, and it was decided on 9th of December 1950. The Constitution bench of 5 judges were there. It was headed by Justice H.R. Kania, and 4 other judges were there. While dealing with this concept, it is interesting to note that 2 judges differ from the concept of this classification, and they gave their dissent judgment. Thereafter, within 6 months, there came F.R. Balsara case. Then the concept was further developed. This doctrine of classification was further developed in the case of Ramkrishan Dalmia versus Justice Tendolkar. And thereafter, this concept continued till 1973, when the first turning point came from this concept of classification, this doctrine of classification, and the new doctrine was developed, doctrine of non-arbitrariness. In Royappa case, Royappa versus state of Tamil Nadu. So in the next video, I'll be taking these judgments of Supreme Court right from 1950 till today, and any other related aspect of the judgment. I'll deal in detail, and how this concept developed one by one. Hope you will feel different qua the right to equality and the concept of right to equality after hearing this video. You will be better able to understand and differentiate while we will be having this journey of constitutional journey, and we will travel to the different judgments one by one in detail. So I wish you should continue with me in the constitutional journey series. And thank you very much. Have a nice time. Take care of yourself and your family at this difficult hour of Corona lockdown, and think of right to equality and develop your questions or your ideas, your comments, and please let me know so that I can help you in best way to understand the right to equality. Namaskar.